Let's see. Ashley Bernie and who?
So Ashley Bernie and Dave Williams on the break.
Oh, on here?
Yeah.
Okay, sounds good. Because obviously they don't know how to do it. Got it. Okay, here we go. Hold'em Investments versus Nora Jones, Alexander Trice, and Derek Trice, 26-04027. Counsel, can I have your appearance, please?
Good morning, Your Honor. Don Keski for the plaintiff. Also on Zoom possibly is Kip Wilson from Renaissance Property Management, agent for the owner.
Okay, I see a sideways view, I believe, of Nora Jones, and this is Alexander Trice.
Yes.
Good morning, Your Honor. I'm Nora Jones.
Okay, and who is Derek Trice?
He is my father. He is the
Okay.
co-signer.
Okay, but he is not present today?
No, he is not a contributing member of the household.
Okay, but he is a contributing member because he co-signed. And he was ordered to be here. Okay, how are we proceeding, Mr. Kesti, on this?
Your Honor, we filed a consent order for conditional dismissal as to Noah Jones and Alexander Trice. We also, filed a default judgment for Derek Trice based on, at the last hearing, you said we could do that.
Okay.
So
Can you put
we have,
terms on the record, please?
okay. The tenants at this point owe a total of $2,578.39, which includes court costs for the period ending August 31, 2026. And the defendants have agreed to pay according to the following terms. The defendant agrees to pay $500 on August 15th, monthly rent obligations of $1,020 by the first of each month, starting September 1st, and an additional $750 due by the 20th of each month until the balance is paid in full. As long as these payments are made, RPM will waive any late fees for September, October, and November.
Okay, and then Mr. Trice, is that accurate?
Yes. I made a $500 payment yesterday.
Very good. Ms. Jones, that's also your understanding?
Yes, that's how I read it.
Okay, you both have the right to proceed to a trial in this eviction proceeding. You could have made a demand for jury trial. Do you understand that?
We do.
Okay, do you want to both waive your right to have a trial?
Yes.
Yes.
Okay, you both have the right to be represented by an attorney in this matter. Did you want to waive your right to an attorney?
Yes, we were able to work with the management company.
I need a response from both of you.
Yes.
Okay, no one is forcing you or threatening you to waive these rights, correct?
Yes.
No.
Correct.
I was gonna say, who's forcing or threatening? Okay, and so you have 3 business days from today's date to return to the court. Request to have this set aside. If you later realize you misunderstood the rights that you waived, partial payment will not satisfy this agreement. So you've got to comply with agreement completely if you want to keep the matter dismissed. Otherwise, if you don't comply, Mr. Keski can file an affidavit and have the case enter judgment against you without any further notice to you for a hearing. Do you understand that?
Yes, I understand.
Does either of you have any questions at this time?
No. No questions.
Okay, you're all set. Thank you.
Thank you for your time.
Yeah, thank you, Your Honor. Thank you.
Thank you, Your Honor.
Thank you. I don't see this conditional. Mr. Caskey, when did you file the conditional dismissal?
That was filed yesterday, Your Honor.
I don't see it in the system at this time.
We also sent you to your email. We sent you a copy with an email as well, along with the default judgment.
If it does, it needs to be filed. I don't see where it was filed.
Yeah, it's both the default judgment and the conditional dismissal were filed yesterday.
Okay. If we don't see it, someone will reach out to you. But it's not in there now. I don't know why.
Okay,
let's-
very, very good.
Thank you.
Thank you.
No
Yeah.
problem.
That's all for us today. Thank you.
Thank you.
You,
Was I supposed to be there?
it's going in the paperwork.
I'll turn the camera on.
Attorney Quinn was here on the first matter that was with Marcus Help. He said he worked out 3 minutes. He's not, Marcus is not here. I think he was probably understanding that worked out.
I don't know where they got that understanding. Ashley Burney versus Danielle Dorman. 26-04024. You, Danielle? You can come forward, please. I see that Ashley Burney is present via Zoom. For today was the date scheduled for a hearing for non-payment of rent. I have a consent judgment. It says the past due rent to retain is due in the amount of $4,960. You can stand up now. Is that correct? Okay, and that there's costs associated with filing this eviction, $163.01. That you'll pay that for a total $5,103.01 on or before the 24th of August, or you'll vacate the property by then. Is that correct? There's also money judgment in the amount of $4,387.53 that you're consenting to being entered as well. Is that correct? And that's your signature down here? Okay, you have the right to be represented by an attorney today. Do you understand that? Are you waiving that right today? You also have the right to proceed to trial. You could have made a demand for jury trial. Do you understand that? Are you waiving your right to trial? Is anyone threatening you to waive that right? You understand that you have 3 business days to return to the court and request to have this set aside if you later realize that you misunderstood your rights, correct? Okay. And so we'll get you a copy of this paperwork in just a moment. Ms. Burney, do you have any questions for the court?
No, I do not.
Any questions for you, ma'am? No. Okay, you're all set. Thank you.
Thank you.
McGuire is in jail. He downstairs. McGuire is in jail. Do that. Yeah. Okay, Mr. Quinn, you worked out an agreement with Mr. Helton, but he's not here. He's not here though. Have his contact information?
No, just what occurred was we were on Zoom the first day. The court put us in a breakout room and he said,
basically work it out.
Right.
So me and Mr. Helton talked, and then we came back out and we put on the record the terms, and then the court asked if I had consent to sign Mr. Helton's name, and we said, yeah, and then I submitted the proposed order.
Oh,
But a hearing was, I think the confusion
we
was.
put the terms on the record?
Right. And I think the confusion was that the court set this hearing date. I don't know why, but but we had already worked out the terms, and I submitted the order, and then that's. Try to reach out to make sure.
If we put the terms on the record, he wouldn't need to appear. It's already done.
Yeah, I just needed the order signed. I think it's already been submitted.
I still have the document. I'm not taking on my desk. So you do. Yeah, I put it on there. I just didn't transfer that's on this. So what's in my name? Okay, let's see here. I think I need to change the date though. What is today's date? The 20th. What date is what? Is it Monday? Yeah. It's all set. I just signed it.
Okay, so I can get a copy of that.
You get that copy? No signed in our base, but just electronic signature, so. It's not signed on there, no. The date change on there, you see where I blocked it out?
Okay.
It's the e-signature, so it's in there. I don't know what to tell you. And I can't give you a wet signature because I gave an egg signature there.
Okay, so it should be with the clerk, so.
Yeah, it's on there, it's signed in there, so I don't know why it doesn't transfer to our printer. And do you see where I changed the right date, and blocked it out? No, that's not it. Yeah, I would go down to the clerk's office and see if they can print a copy, because it's changed in my on base.
I got you. Thank you.
No problem. SK Lansing Limited Dividend Housing versus Stephanie Cooper, 26-04109. Minutes, please.
Morning, I'm Justin, preparing that plaintiff.
Your name is?
Stephanie Cooper.
Okay, today was the date scheduled for hearing. This is for non-payment of rent. See this in my docket. I don't see this one. This should be- Oh, I see it now. Okay, let's see. There's a consent order for conditional dismissal. The matter will be dismissed today upon the condition that you pay past due rent through a period of August 30th, plus for cost total amount $4,380.08, correct? Yes. It says defendant pays monthly rent by the 5th day of each month, total due $4,380.08 as follows: 730 on or before the 25th of August, the 25th of September, October, November, and December. Final payment of $730.08 by the 25th of January 2027. Is that accurate? That's your signature? You have the right to be represented by an attorney. Did you understand that right? Are you waiving that right today? You have the right to proceed to trial. You could have made a demand for jury trial. Do you understand that? You understand that? And you're waiving that right as well? Partial performance will not satisfy this. So you would have to pay according to that time schedule that you stated there if you want to keep this matter dismissed. Do you understand that? If you don't comply with that agreement, Mr. Pooh can file to have judgment entered against you. You will not get another hearing date. Do you understand that? You have any questions at this time? You have 3 days to return to the court and request to have that agreement set aside if you ever realize you misunderstood the right that you waived, okay? We'll get you a copy. Any additional matters for the record? Yeah. All set. Thank you. Todd Doward versus Ryan Nelson, 26-04036. Ryan Nelson has failed to appear, correct? Judgment will enter in the amount of $2,899.12. He had personal service, correct? Okay. So money judgment will enter as well. What's your name? I didn't call your case.
She's the same case, though.
She is the same case?
Yes, there should be 2 judgment forms.
Okay, yeah, there was a separate judgment form. I just called the one that has his name on it. That's why I didn't understand. Okay, got it. Okay, you can stand there, ma'am. This is Todd Doward versus Whitney Patterson, 26-04036 LT. You're Whitney Patterson?
Yes.
Okay, both are present in the courtroom. This is a consent judgment. Says past due rent is due in the amount $2,899.12. Give me that form back, please. And money judgment is also going to enter against you $2,102.34. Is that correct? Yes. Okay, you understood that you have the right to have an attorney to represent you?
Yes.
You want to waive that right?
Yes.
You also have the right. You also have the right to proceed to trial. You want to waive your right to trial? No one's threatening you to do waive these rights, correct? Judgment will enter against you by your consent for money judgment As stated on this paperwork, you have 3 business days to return to the court and request to have this set aside if you later realize you misunderstood your rights, okay? You have any questions at this time? Madam's counsel? Where did this job go? Right here. Okay, are we ready? You just step to the side, please. Are we ready on your matter? And the witness is here? Yes. Okay, very good. Okay. All the jurors are here. People of state of Michigan versus Rhonda Wade, 25-03773. Appearance for the record.
Ross Marchino for the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Wade, who is standing to my right.
We are ready to proceed with further testimony. This is, I guess, your witness technically.
No, my understanding was that that's one.
Okay, you want to call them? That's correct.
Yes, but it was.
Okay. Okay, it was your witness, but you're gonna call. I just wanted to make sure I didn't have to help allow him to reopen the proofs. So that's completely fine. You have not technically rested, so that's fine. We'll call the witness after the jury's brought in. Any preliminary matters?
Nothing from the people.
Not from the bench.
Okay. Who's the next one? Happened? Yeah, to me, what happened? Did this look like it was monthly? I didn't do it. You asking the wrong person. I wasn't there. Somebody can look it up and tell us. Okay, you can be seated. Okay, thank you for your patience. We are also running a landlord tenant docket scheduled for today, so there may be some interruptions, but we're going to try to get through this as quickly as possible to get you to deliberation. So I think we have another witness. You can call your next witness.
The defense calls Mr. Officer Mark Fox.
solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
You can have a seat. Okay, you can state your first and last name and spell both.
Mark, M-A-R-C, Fox, F-O-X.
Seat, counsel.
Mr. Fox, what do you do?
I'm a police officer for Lansing Police Department.
Okay. Were you working on the morning of June 13th of 2025?
No,
Okay, what about on the morning of June 14th, 2025? In the wee hours?
yeah, I need to be more specific on the time frame. I work midnights. So,
Okay, so around almost 1 o'clock in the morning of June 14th.
probably,
Okay, and did you respond to an address on Hazel Street?
I did.
Okay, and why did you respond there?
I responded there to take a late assault report.
Okay, and why was it in a late assault report?
Dispatch advised me that there was an assault report that needed to be taken at Hazel Street while I was on duty.
Okay, and had officers responded to that address earlier in the day?
I'm gonna object to lack of foundation as to his knowledge of officers having responded earlier in the day.
You can ask if you're aware of officer responses, I guess.
Dispatch advised me that officers had responded earlier in the day prior to my.
Okay, and why hadn't they taken them?
Okay, I'm gonna object again because, I mean, first off, definitely he just gave us hearsay, dispatch advised him.
Did they
Lack of
provide you-
foundation as to how he would know
I'll rephrase
what
it.
officers who may or may not have gone did.
Right, and I'm assuming you're asking these questions for what purpose?
Well, Your Honor,
This is being
to,
for the truth of the matter asserted. Or effect on the listener, why are you asking this line of question?
I'm asking this line of questioning to understand why Mr. Fox responded much later.
Objections overruled as to hearsay because she's asking to find out why he did what he did. Okay.
Were
So
you
can
ever
continue.
advised by dispatch for why you were responding?
I received no particulars other than I needed to take a late report for an assault.
Okay, so you don't know why after officers responded earlier in the day, there was
I'm
no.
gonna object, it assumes a fact, not an evidence.
Your question and an objection came at the same time, but will you complete your question?
So he doesn't know why the officers earlier in the day did not take a report.
And my objection is because there's no evidence that officers earlier.
I thought that his testimony was that,
That was not officer the truth.
I didn't
I'm
I
sorry.
didn't finish saying my statement. I thought his testimony was that he responded because he was told to take, that there was she asked why it was a late report. That was the question. And he said that there was an assault and no report had been taken. I thought that was his answer.
He indicated that dispatch notes indicated that officers were there earlier, which was, the
So
court
sure.
board was not.
Yeah, but he's already said that there's no report had been taken. So your follow-up is this, did you know why there was no report taken? Still trying to figure out why he's doing what he's doing.
Okay, understood, thank you.
I have no idea why no reports.
If you were to read your report, would that refresh your recollection?
Sure.
May I push the witness?
Yeah.
I do need to object because he said he doesn't know why, he didn't say he doesn't remember why. So I don't think there's a memory.
That's the truth. If you didn't say you didn't remember, you would have to maybe re-question him about whether or not he addressed that in his report. I don't know.
Okay, do you remember whether or not you addressed that fact in this report? In
Which-
your report
Which fact?
of why the report was not taken when the officers responded earlier in the
Okay,
day?
I'm gonna object because, again, it's assuming that officers responded earlier in the day. There's no
He already said that.
facts and evidence. What he said was dispatch notes said, which again was not offered for the truth. So I'm going to object to questions that assume it's fact that officers responded earlier in the day, given that that's not.
Okay, you're trying to figure out why he took a late report.
Correct.
Okay, and your position is that this is addressed in the police report.
Yes.
Okay, and that his answer is not consistent with what you feel is in the police
Correct, Your
report? Okay, objections overruled.
I want your direction to this perfection. So I will repose my question. Do you know, or did you indicate in your report why the officers had not taken a report earlier in the day when they responded?
The information indicated in my report was based off CAD notes. So that's notes that come through our computer automated dispatch system. I was simply explaining why I was there, what the report was for, and why I showed up later in the evening to take the report for an assault.
Okay, so explain that to us now. Why you showed up later in the evening to take a report when we're.
I'm gonna object. He's been asked and answered. He's made it pretty clear that dispatch told him to go take a late report. I think she's not getting the answer that she wants, but that doesn't mean you can ask the question again and again until you get an answer.
Yeah, he's answered that
Did you identify in your report this reason?
Yeah, counsel approach. Yes. For the record, that objection is sustained.
Officer Marcox, did you indicated in your report that officers had responded earlier that day and that the victim did not want to press charges at that time, is that correct?
I indicated that in my report.
Okay, thank you. Now, you weren't present for this alleged incident, were you?
I was not.
So you didn't witness anything regarding this incident firsthand, did you?
I did not.
Okay. So all you know about the incident came from the complaining witness, Ms. Bowers.
Correct.
And her mother, correct?
I believe her mother was on scene during the interview at
Okay.
the residence.
Okay, so they weren't separated.
I don't recall. It was over a year ago.
Okay. If I were to refresh your recollection based on your body camera footage, would that refresh your recollection?
Yes.
May I approach the witness, Your Honor?
Yeah.
After having watched a few seconds here of this, does this appear familiar to you?
I'm going to object at this point. I don't know if she's planning to. My understanding is that she's refreshing his memory. So I think the question would be, does this refresh your memory? Not, is this familiar?
I would need to watch it.
Okay.
This looks like every other call center in the
agree.
block in the city.
Okay, well, let's get you to the actual.
Sounds like it hasn't refreshed his memory yet.
Okay, yeah. I remember.
Remember?
Or did you ask for the refreshers?
Yes, so my question is, everything you know about this incident came from the complaining witness and her mother, correct? And they weren't separated.
I don't recall if they were separated the entire time, or they were together the entire time. They were obviously there when I arrived on scene for the body camera footage. She showed me the first 5 seconds of me arriving on scene. They very well may have been, or may have not been. I don't recall at this time. So I'd have to watch the whole thing over again.
Okay, Your Honor, would you allow him to watch the whole thing? It's 21 minutes.
We're not gonna sit here for 21 minutes for him to
Fair.
watch a video.
Fair. So if I showed you the middle of the video
Yes.
and the last bit of the video, would that help you?
Yes.
Or I guess I do want to put an objection on the record in that Carliona was here yesterday and could just ask her, were you and your mother separated when you spoke to the police? I don't think it's necessary to go through.
She's not the best person to respond to investigative
She can
questions.
ask this what, you can't object because she's asking this witness that question. She can ask this witness that. It was
Understood.
his investigation.
That's for a couple. So,
Okay, so during your interview of Ms. Bowers, her mother interjected quite a bit, didn't she? In fact, 26 times in 21 minutes, correct?
I didn't hear the answer for the first question. Did you answer?
I did not.
Oh,
Possibly. I don't recall exactly the entire interview. That's why I wrote a police report with the facts that I took the interview.
Okay.
I don't recall 100% how many times she interjected or what her statements were.
Okay. Generally, when police are investigating assault and battery, they tend to respond to those incidents relatively quickly, right?
Yes.
Right, because there are concerns regarding investigations relative to timing. Right, we don't want too much time to lapse, correct?
I guess that's a true statement, yeah.
And that could essentially affect the quality of evidence, right?
Depends on the crime, yes.
Okay. One of the major reasons for that is reliability, isn't it?
you said reliability?
Yes, the reliability of the evidence.
Yes.
Because a lot can happen, for instance, in 16 hours.
Yes.
For example, we might not be able to tell how old injuries are, right?
I'm gonna object. That's lack of foundation. That's between his ability to age injuries.
As is, I have my fan on, so I couldn't hear.
Sorry,
what you said.
his ability to age injuries.
Okay. Did you want to respond to the objection?
I'm not asking him if he can age injuries, Your Honor. I am asking him whether or not his training as an investigator tends to indicate that injuries might look older, or that you should not wait to investigate injuries for a long time, as it could change the appearance of them.
You're asking if that's his training or his experience?
I am asking about his training.
He can answer if that's part of your training experience. So the objections are ruled.
I am not an expert in aging, judging injuries based on age.
What about investigating injuries
I can document them. All right.
and relative to timing of that documentation? What's your training there? Do you have any training there?
I guess I'm confused about the question. My job as a patrol officer, I document, I take a report, I document the injuries that the victim has. That's why we take pictures of them and I write a report and then that goes to a detective.
Okay, but you don't wait days to document injuries, right? You generally document them as soon as you can, right?
It depends on the investigation. Yeah.
So there are instances where you will allow for significant time to lapse before you document injuries.
I don't understand the question that you're asking me. Because someone has injuries and injuries tend to get worse over time. So I document the injuries that I have right in front of me. Let's say, for instance, a domestic assault. I would document the injuries that I have in front of me at the time that I took the report. Okay, and injuries tend to get worse over time. So they want it documented at the time that it happened or the time I'm taking the report. And then-
Excellent, thank you so
and
much.
then
That's perfect, that answers my question. Now, during the interview with Ms. Bowers, it must have seemed odd to you that her mother kept interjecting if she wasn't present, right?
I guess I'm going to object on her testimony that she wasn't present, and if there was such testimony, if you could stop.
You objecting as to if she wasn't present because of,
Well, the question assumed that Ms. Bauer's mother was not present at the time. I don't know that there was testimony to that effect, and
We
if
have
this
ample
witness is,
testimony to that effect.
well, if this witness is speaking on her not being there, that would be hearsay.
He's interviewing these witnesses.
yeah, I think he could testify as to whether or not during his investigation, he determined that she was present. I don't know that that's been a question.
Well, I guess the only way he would determine she was present is based on hearsay.
Well, his investigation is all he was saying.
That is, well,
All of
I
his
mean,
entire
I would-
investigation is hearsay. That's what the investigation is.
yes, but
He
what I'm
asked,
saying, that's
he
why
would
we
have
have
asked
the
the
witnesses.
alleged victim what happened. The document, all of it would be hearsay.
Yeah, and we're not allowed to have him just repeat
Right,
what witnesses
he's not, she's not asking him to repeat what he said. He could determine whether or not through his investigation if the people were present or not. So that objection is overruled.
just question.
But you didn't actually ask that portion. I rephrased it. So you might need to rephrase your question, because I don't think you remembered it.
Okay, so you generally don't take information from witnesses that weren't present, do you? You generally don't interview them.
If they weren't present, no, for the incident specific to what I'm investigating.
So then if a witness wasn't present and they start to interject, that would seem a bit odd to you, right?
Yes,
And wouldn't that generally tend to indicate you probably should separate those two people so as not to allow that person who wasn't present to influence the testimony of the statements of the person who was?
sure.
When you were capturing your statements from Ms. Bowers and her mother, they never claimed that, or she never claimed that anyone placed their hands around her neck, right?
She.
Ms. Bowers.
Okay, I'm going to object again to hearsay. He's just asking him to repeat what witnesses said, and like we went through the song and dance yesterday about prior inconsistent statements, which that exception doesn't apply to. It's not inconsistent. We're having the same
not
conversation we
inconsistent?
did with the investigator.
What's not inconsistent?
Okay, she wanted to ask the investigator
Correct.
about hands on neck,
Well,
and we
it's all
determined that he
correct.
couldn't,
We're
and now
talking
she
about a
wants to ask.
conversation we had outside of the presence of the judge.
Now
You can
she's trying.
approach. Okay, that question is withdrawn.
When you were meeting with Ms. Bowers and her mother, you did gather evidence related to injuries, correct?
Photographs?
Correct.
Correct.
Yes. And at no point in time did you ever photograph her neck, did you?
I don't know. I don't recall photographing her neck.
If I show you the photograph, would that help?
Sure.
Your Honor, may I approach the witness? You may.
Sorry.
Yeah, it's good. That's
Yeah, exactly.
Yeah. Yep.
Okay. Let me ask one question. With the pictures that you took, you never took one of the neck, did you?
No.
You did, however, take other investigative actions in addition to taking notes from your interview with Ms. Bowers, right?
Yes.
Tell us about those.
And I interviewed the victim.
In addition to that,
I took photographs and then I gathered video evidence from a ring camera.
got it. So you had Ms. Bowers kind of show you and reenact what happened in the living room?
Yes.
Are you sure?
Be honest with you,
Because you couldn't recall just a few minutes ago what was on your video camera, and now you can.
what do you mean reenact? I often ask people to show me exactly what happened and where you were located in the house.
And you
so-
remember doing that with Ms. Bowers?
No, I don't think I remember 100% of the entire investigation. I guess I'm confused. You're asking me if I got more video
I
evidence?
think you answered my question that you didn't do it. Relative to the other witnesses, did you gather any other statements?
I interviewed the two people that were there. That's the people who were
But
present.
you knew about other witnesses too, right? Did you ever interview them?
No.
But you surely knocked on neighbors' doors to see if maybe anybody else witnessed anything.
No.
You mentioned ring camera videos. You did follow up with Ms. Bowers' mother to make sure that you had the full ring footage rather than just that little snippet, right?
But it's not my job.
Not your job. Okay, understand. What about the bumps that were alleged to be on the back of Miss Bauer's head. You put on a latex glove and checked the back of her head, right?
I did not.
Even after she showed you?
I did not touch the victim.
Isn't it possible that you missed a good chunk of what actually happened due to Miss Bauer's statement being captured many hours later, you not interviewing anyone else, and you not reenacting and doing other investigative steps?
I don't understand the question. My job is come take an initial report, to the patrol officer. So we have detective bureau for an investigator.
Okay, there's a difference between understanding my question and not liking it.
I just don't understand it.
Isn't it possible that a lot of the evidence was missed in this case?
In my initial investigation on scene, I'm sure there's a lot more evidence.
Thank you. No further questions.
Okay. Just to clarify a couple things. Is it correct that in your police report, it indicated that prior officers responded and the victim did not want to give a statement?
Yes, they need to do that.
And isn't it also correct that that's information that you got from CAD notes? And can you please explain to the jury where CAD notes come from?
So, I have a computer system, it's called computer aided dispatch, and on my computer in my car, I will get a call. So I'll get sent to a call, and then in that call, I can see notes that were in there. And dispatch will put things that happened prior. Let's say there was an issue earlier in the day or a different day. They can put notes in there, and I can read those notes. And then I go to the call.
And did you ever personally speak with any officers who may or may not have been there earlier in the day?
I did not.
Now, on June 13th, your June 13th and the June 14th shift, what time did you start working?
20-30 hours, so it's 8:30 p.m.
So if something occurred at 8:30 a.m., you weren't even working until 12 hours later, is that correct?
Correct.
Now, if there was information that someone had tried to report this to the police that morning, would you have any reason to dispute that?
No.
Now, when you spoke with the victim by the time, okay, approximately what time do you recall you arrived there to speak with the victim and mother?
I would say somewhere between 12:30, 1 a.m., I believe, in the morning. So early morning.
Now, at this point in time, did you indicate that only the victim and her mother were on scene?
I believe I indicated only the victim and their mother were on scene when I was there.
Okay. Now, is it common police practice when someone says they have knots on the head to start feeling their head to try and feel the knots?
No.
You're not a detective, is that right?
No, I am not a detective.
So then it's not your job to then run around and interview all the witnesses who might have been, right?
Correct.
That would be a detective's job.
Correct.
All right, no further questions.
Officer Fox, you don't dispute that it is somebody's job, though, to investigate, right?
I don't dispute that.
Thank you. And you do recognize that you had a very clear memory for the prosecution when they just examined you versus when I examined you, right?
Yes.
No further questions.
Questions from the jury for this witness? So this be excused?
Yes, sir.
Yes, Your Honor.
Thank you.
The other witnesses, rebuttal witnesses.
No rebuttal witnesses, Your Honor. Thank you.
We went over the jury instructions yesterday. I'm happy to proceed right into those.
I think that we do not need to add the.
I agree.
Yeah.
He's here. So I think the way that we left them yesterday are sufficient. We can just do the closing instructions and do your final argument. I don't know what's going on with Jessica Shaw. She keeps trying to log again, but she's already here. So, okay. So that concludes the,
We include the instruction. It's on the testimony.
Yeah, I
okay,
do
let's
think
give
that we're
the
gonna
jury a break then. All rise for the jury.
I can bring the parties.
Yeah. And who was this that was late?
Jasmine.
Ms. Patterson, why were you late?
So I was getting ready to come here, and then my brother called me at the last minute saying that he was gonna take my daughter to camp, like he has been doing for the last 3 weeks. He works for Massey School District, so.
Oh, I think that's the attorney, because that's the issue. The attorney came and left. So we tried to call and have him come back. So we're trying to see if he can log in. Because it sounded like you all worked out an agreement. Okay, he'll be back in 15 minutes. This is Wayne Brewer versus Tracy Metcalf. And all other occupants. 26-04043. Ms. Tracy Metcalf and all other occupants.
Miss Metcalf.
Oh, was that you? You come forward, ma'am. Appearance, please.
Attorney Marcus Felder on behalf of plaintiff Wayne Brewer.
Okay, I have a possession judgment here that you're looking to have entered by consent. It says rent to retain $3,450. Is that correct?
That's correct. That represents 3 months that have been unpaid that Ms. Metcalf acknowledged and, wants to make whole. She agreed to move out by September 10th. We're giving her basically 30 days from now. I discussed this at length with Ms. Metcalf.
Ms. Metcalf, you can stand up. Is that correct? Okay, other money due $250. What's that for?
That's a cleaning fee that's indicated in the lease. I did tell her, if it's cleaned, et cetera, we may be willing to waive that. It's not a big deal. It's indicated in the lease, though. It's a $250. The court wants to strike that.
You can't put a cleaning fee if she's for money due. It's not due unless she vacates.
Okay. Thank you, Your Honor. That's my mistake.
Okay.
I apologize.
Okay. Were there court the reason what originally is calling me to pay closer attention to this is the $3,700. I've never seen money judgment calculated this way, so I don't believe it was calculated right. Damages and costs have to equal something. And I just see $3,700, which is the total that you just brought down from the possession.
Okay.
So that's the concern. But yeah, the other money due, we can't deal with that because it's not due. She has the right to pay and keep possession. And so the only way I can do, if that's what you all want to do, then you would have to do a conditional dismissal or something.
And I have that form as well. For some reason I just thought that one page might work better. I have a conditional dismissal as well. That's not filled out, but.
So that's different because then the terms could be if she's going to vacate.
Okay.
Then obviously she's going to agree to pay that and it can be waived. You can clarify some of those things more in the other language. But if a judgment, this is a possession judgment, so she's allowed to pay a certain amount to maintain the property before the 10th. That cleaning fee can't be included in that if she's going to stay.
I understand. You're right. The thing that.
So it's really up to how you all want to do it.
Yeah, I saw on that judgment form, there's one that I checked on it that said it will not prevent the court from issuing an order of it, acceptance.
Partial performance.
Okay, and I'm reading that now, and I see what the court is saying, and I'm basically the general gist of it is we're agreeing she pays the 3 months rent and she's out. It's September 10th. That's the agreement. And whether that can be accomplished through that document or whether the court thinks it's more practical for this consent judgment.
I agree. She's saying that she's going to pay the 3 months and vacate. But she could change her mind by law, pay the 3 months and not vacate is what I'm saying. So that's what this is saying. So it does say plaintiff can apply for an order of evicting the defendant. The defendant does not move out by the 10th.
Right, and I read that as well.
Okay, and then money judgment, what's the past due rent, it says is $3,450.
That's correct. That's correct. And we can strike the other 250.
So the 250 again is other money for cleaning, for her vacating, but that you said could be waived. The problem is she has this judgment. Let's say you do waive it, the judgment will not be satisfied. And so I think that's the concern. Unless it was your plan to come back and dismiss this if she complied.
No, the
Yeah.
agreement is for her to move out by September 10th.
Yeah,
That's,
so then the judgment will never be considered satisfied. So if she could easily come back and say, I want a satisfaction of, or I need a satisfaction of
right. I hear what the
judgment.
court's saying.
And you all waive this 250, a new attorney is in your place and doesn't know that was something that was waived. She could end up in a bind.
Okay, so we can fill out this consent conditional dismissal. That may be more appropriate for this case.
Yeah, but then that would dismiss the case upon the condition she does the same things here. And I thought you just said you didn't want to do that, because that's
Right.
why I said we can do it this way if the agreement is that you're going to, I guess, dismiss it if she complies.
The agreement.
Because the money due right now is not this 250. So I think that just needs to come
That
off.
can be stricken, Your Honor.
Got it.
We agree to
And
do
then
that.
we can keep the rest as it is.
Okay, yeah, you're right. And the idea is, she agrees moving out by September 10th and that outstanding rent.
Right.
remains.
So if I'm assuming she doesn't have a security deposit, is that the issue? You didn't pay a security deposit, man?
I did pay a security
Oh, well,
deposit.
then how come the cleaning fee couldn't just come out of that?
It could, yeah.
Okay, so we'll take the 3, and there was no court costs?
I didn't want to get into that right now. We're gonna waive that.
Got it, okay, so waive those. So it's just 3,450 is the total. And then damages, same amount is what you're looking for.
That's correct, Your Honor.
Okay, and that, you understand what just happened there, ma'am?
Believe so.
What happened was I told him that the judgment cannot at this time include the cleaning fee
Right,
because that's not due.
I understand
That makes
that.
Okay, and so only thing due right now is this past due rent.
Mhm.
And so that, we just took off the cleaning fee. So now the past due that you owe is $3,450. Okay, that's also the money, the amount you're agreeing to for a money judgment, is that correct? And that you are agreeing to pay this and vacate by the 10th?
I can't say that I can have it paid by
Okay,
the 10th, but I
you're-
can
but
say
you're-
that I
you're-
can vacate
You're gonna
by the
vacate by the 10th.
That's my plan.
Okay, okay, you understand that you had an attorney, or you had the right to have an attorney to represent you? This is not signed.
I do, but I couldn't find legal counsel.
Okay, so you're waiving your right to counsel?
I don't want to waive my right to counsel. I just couldn't find legal counsel.
Okay, if you don't waive your right, we can't proceed.
Okay, I apologize. Could you explain that?
You have the right to have an attorney represent you. And so when you appear without an attorney, whether it's because you couldn't afford or you just decided you not to, you still have to decide if you're waiving your right to represent so that you can represent yourself.
I never wanted to represent myself.
Okay, well then we can't proceed.
Well, I don't want to give counsel to Ms.
You can't
Metcalf,
give
but
her
I can't,
counsel,
I
yeah.
can't.
She doesn't
So,
want to waive her right, then she's,
but well.
the only other thing I can do is at the, when they deliberate, I can have a hearing and it'll enter the same way. That's the only, it's a semantic.
Yeah, and I'm gonna
Yeah.
request that.
Yeah, that's all I mean. So you can have a seat and we'll do the jury instructions and I'll call your case back.
Okay.
You can bring the jury back. Let's see.
All rise for the jurors.
So you can be seated. You can fix your attention to the screen. We do have some composite or final instructions. Okay, members of the jury, the evidence and the arguments in this case, well, the arguments are gonna go after this. I'm giving them time to compile their thoughts. The evidence in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true verdict, true and just verdict based only on the evidence and my instruction on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that. Sir? A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. We can remove that one, she did testify. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in the case. Therefore, it is important for you to understand what is evidence and what is not evidence. It was 3.3. Evidence include only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, ruling, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony it is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on a gender, race, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about June 13, 2025 within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that the discussions are carried out in a business-like manner and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones and other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all of my instructions together as the law that you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and a full copy of the instructions. If you want to look at any of the reference documents or the exhibits that were omitted, you need to just have your foreperson write it on the note and we will get you back in because I think they were all video. I don't believe we had any other exhibits. It was all video exhibits.
Oh, there were photographs.
Oh, there were photos. You have the photos?
Yes, I.
Okay, very good. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider any such out-of-court statement against the defendant, you must first find the defendant actually made the statement as given to you. If you find that the defendant didn't make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person coming from outside wearing a raincoat with small drops of water, that would be circumstantial evidence that is raining. You may consider circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of it. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she did, what she said, and how she did it, or by any other facts and circumstances and evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. These are the elements, again, of assault and battery. The defendant is charged with assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon a Carliana Bowers. A battery is a forceful, violent, or offensive touching of the person or something closely connected to the person of another. The touching must have been intended by the defendant. That is not accidental, and it must have been against Carliana Bowers' will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Carliana Bowers or to make Carliana Bowers reasonably fear an immediate battery. As used in this instruction, the words force and violence means any use of physical force against another person as to harm or embarrass him or her. The definition of touching: for a battery to occur, the touching must have been intended by the defendant. That is not accidental, and it must have been against Carliana Bowers' will. It does not matter whether the touching caused an injury. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. The defendant has now asserted a defense of self-defense. The defendant does not have to prove that she acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. Self-defense as a defense or defense of others. The defendant claims that she acted in lawful self-defense. A person has the right to use force to defend herself under certain circumstances. If a person acts in lawful self-defense, then their actions are justified and they are not guilty of assault and battery. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to her at the time she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had to use force to protect herself from imminent unlawful use of force by another. If she believed, or if her belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect herself or the other person from danger. The defendant must have used the kind of force that was appropriate to the attack made in the circumstances as she saw them. When you decide whether the force used was what was or seemed necessary, you should consider whether the defendant knew about any other ways of protecting herself. But you may also consider how the excitement of the moment affected the choice the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that does not prevent her from claiming self-defense if she was attacked. There was only one other jury instruction that should have been added. I just thought about it. And that's because the officer testified. I was actually here on the slide. Just need to- Okay, you have heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Okay, that concludes jury instructions. You can do your closing arguments.
That's the HTML.
So I need to
Yeah,
give
they
you
need
permission
to-
every day, is that what's going
That
on?
way.
Okay, try it again.
I told you guys from the jump that this was gonna be about credibility, and I was right. That's what we're gonna be focusing on. You heard testimony from the 5 witnesses, 4 of whom were all there when this happened, and it's gonna be your job to decide how credible people are, decide who you think is telling the truth. And it's my job now to convince you that beyond a reasonable doubt, the first 2 witnesses you saw were the ones who were telling the truth. And the next 2 witnesses you saw were lying to you. And let's start first by talking about Carliana. Let me explain to you why she was a credible witness, why you should find her credible. First off, I would note that her story was consistent. Okay, because we did hear actually one of the several phone calls that she placed to Central Dispatch when she initially tried to make this report. And she testified that it was, maybe an hour later. And she did describe it was hard to hear because of all the background noise on the call. But she did say, my sister barged to my house, knocked me down, and was hitting me. And that's the same as what she testified to today. Now, you're also going to, a lot of people talked about body language. Let's talk about her body language. First off, she clearly was nervous. She's a young person, she's a teenager, and she's here in this intimidating room, close proximity with the sister sitting right here, lawyers right here, jury staring her down, evaluating her credibility. So it's clear that she was nervous. She was talking very quietly, which further demonstrates that she's nervous. It was not demonstrating a person who is motivated to get someone in trouble, who is here motivated to frame someone for something that didn't happen. That's going to be the defense's position, is that she was here killing her sister for a crime that didn't actually happen. And I would submit to you that she was making an honest effort to tell the truth. That was in the instruction about that you just saw a second ago about evaluating witnesses' testimony. Did they appear to making an honest effort to tell the truth? She was honest about things that she didn't know. And that's something that I like to emphasize because it does seem to me like it shows that they're being credible. And I'll get to this momentarily, but I think that you did see that the defense's witnesses remembered everything to the truth. And I would submit that that undermines the credibility. We'll talk to that. She was honest about the fact that there were things that she couldn't remember very well. Usually when someone's in custody, they sweep them in the jury box, and obviously that's not available. So we'll let the distraction dissipate and we'll get back into it. Don't worry, there's plenty of places where we can go and find.
I did and just moved.
So it's just a day in the life. There's other stuff going on. Apologize for that distraction. But her being honest and then her memory being refreshed and then things come back. Okay, that's how memory works, right? You talk about things. I think at one point when Miss Rog here was like, oh, but now you're saying this as if she had got her. She just stepped in the mousetrap. He said, well, my memory is coming back now that we're talking about it. I think that we've all had conversations like that, where we're kind of like, oh yeah, and then this happened. Oh yeah, and this happened. Because keep in mind, it's been more than a year. So she's not going to remember everything perfectly more than a year later. And I don't need for her to remember everything perfectly because this is a pretty simple charge. What I need to prove is this involuntary, intentional, harmful, offensive contact. So I don't need to prove to you that she remembers in perfect detail exactly what happened, how it happened, the order in which it happened. So all of that, when put together, suggest that she's telling the truth, that she's doing her best to tell the truth. And, get into her body language during cross-examination. I have to take my hat off to Ms. Rob. She's very good at cross-examining witnesses. I think that she flashed that a few times. She's certainly better at it than I am, right? Prosecutors, we call witnesses, and defense attorneys tear them apart. That's the differences in our job. It's something that she does more frequently, and she's very good at it. And I think that most of the inconsistencies that you saw in Carleone's testimony were mostly a consequence of the defense attorney tripping her up, the defense attorney badgering her, the defense attorney accusing her of changing her story, right? We've got this teenage girl who's seated up here with this intimidating professional who is attacking her in a way that crime victims generally aren't subjected to. I've heard Ms. Straw before use the term the crucible of cross-examination. And that was on full display. So when someone whose whole life, whose livelihood depends on making a person question themselves, I'm poking hole in a story that the person is trying to tell, right? Because when we're having a conversation and I'm telling you a story, generally you're not trying to poke holes in my story. So that right there is not something that I think that I would suggest speaks to her credibility. It demonstrates a lack of truthfulness, as the defense, I assume, will suggest to you it does. Now moving on to Brianna, who again, I would urge you to find credible. There are some keys to her body language I would look to that I think is worth noting. She was clearly doing her best to recognize the formality of the court, right? She was dressed very nice. She was sitting up straight. She was making eye contact with this question and trying to be, I would suggest she was trying to be very matter of fact, doing her best to directly answer the questions that are being asked. And again, I'm going to suggest that what you saw was an honest effort to tell the truth. Now, one thing that I imagine is going to be harped on is that there were some differences between her recollection of what happened and Carleone's recollection of what happened. And I think that we all know that's normal. I regret not talking about that in jury selection. Sometimes I do talk about that in jury selection. I, of course, wasn't aware until the testimony came out that there was going to be some variation in what they were saying. But what that demonstrates is that the two of them did not make a conspiracy to take down Ron. That demonstrates that they never sat down and got their stories straight. Okay, and we'll touch on this more, but Miss Wade discussed having a clear memory of, well, that bedroom door was closed, because both of our witnesses testified that the door was open, and Brianna said, well, I could see the end of it through the bedroom door because the bedroom door was open. And Rhonda Wade testified, well, I was there for 2 minutes over a year ago, and I remember that that door was closed. So if you're accepting her version of events, that would mean that all the information that she had, that she testified to, that she claimed she knew, was fed to her by Carleone Chowers, which then begs the question, why is she feeding a different story? That is something that doesn't make sense. And I'm going to ask not to take that bait. I think that one of the instructions might have talked about, well, sometimes witnesses testimony don't line up because they don't remember things the same. And I have to imagine we're all people here, okay? When you become a juror, you don't have to stop being a person, and you don't have to flip off your brain as to how you know people to operate. And I think that everybody here in this room knows that a year later, people are not going to remember things the same. Memory is very strange, and that doesn't mean that someone is lying or that someone is fabricating. Now, let's talk about Helen Wells and why she was not a credible witness. First off, that we need to recognize is the relationships at play. Now, in terms of incentives, why I recognize there are some parallels between Tella and between Brianna, and we'll get to that. But let's start out with Tella Wells' relationship to Rhonda Wade. These two are, I know that Ms. Straub used the word half-blood, full-blood sisters, half-blood sisters. That's not a term that I use, but since that's been introduced, they have two parents in common. And I'm not going to suggest that automatically you are closer with a sibling because you have two parents in common, but that doesn't suggest that there's a likelihood that they spend more time together. They're much closer together in age, and it's very clear that they have had a lot more time around each other. On the days this happened, we saw that Tella went to the house with Rhonda. And then today or yesterday, they come into court together. They're working together. The two of them are on the same side, right? So we have a clear incentive here on the part of Miss Wells to try to help her sister, right? It's clear, yes, she's sisters with both of them, but it's clear that, I mean, it's common, right? You all know people with siblings. Sometimes you have this sort of divide where you have two siblings who have two parents together who are much older than the other ones. And she has this incentive here to have her sisters back. And I would submit to you that that's what we saw in Tella Wells. Now, another thing that I would talk about with her testimony is that she remembered everything very well. That was something they both had in common. And that is something that evidences a story being cooked up. That evidences, I'm not going to say that she stood in the mirror and rehearsed her lines, right? But that demonstrates that she came in here knowing what she needed to say to help her friend get out of trouble. Okay. Now, let's talk a little bit about incentives to lie. Okay, because that's everybody does things for reasons. We have reasons for doing what we do. Okay, I am here today because this is my job, right? I need to make a living, and that's the reason I'm here. You guys are here because you got a summons in the mail saying you need to come in here and you need to report the jury duty. Okay, so everybody has motivations to drive the things that they do. So let's go one at a time and let's see what incentive witnesses have to lie. And let's go in reverse order. Let's start with Rhonda Wade here. What incentive does she have to lie? Well, it's pretty simple. She is on trial for assault. So her lying advances her interest in not being convicted of assault. That is the clearest incentive that you have to tell a lie. Now, obviously, it's possible, that she's testifying as she did because that's what actually happened. But in terms of incentives to lie, which is very important in terms of assessing the witness's credibility, the clear as day one is that this individual right here is on trial. And she doesn't want to be in trouble. She doesn't want to be convicted of it. Now let's talk about Tella Wells and her incentives to lie. We touched on it a little bit. She's very close with her sister. And another thing that I think sort of took away from her credibility was her efforts to say, well, I'm just as close with Carly. We haven't talked in a long time, right? But I'm equally close with both of them. Okay, so that's something that I further would submit took away from her credibility. But getting back to her incentive to lie, is she has this very close relationship with Rhonda. And she has an incentive to help Rhonda. She doesn't want Rhonda to be in trouble. She wants to help with that. And then also, as we saw on People's Exhibits 4 and 5, the two of them went there together. So how does it make her look if she is perceived as helping her sister go over to his house and beat up his other sister? So there's some very clear incentives to lie on the part of both of these witnesses. Now, continuing to move forward, Brianna Williams. Let's talk about her incentives to lie. I'm not going to be dishonest with you and say that she doesn't have an incentive to lie, because she does. She is best friends with Carliana. And the incentive to lie here would be having her friends back, right? However, I would still suggest that she's more credible than Tella. We kind of have these, they're almost counterparts, I would say. I would suggest to you that she is more credible than Teller is. Okay. And there are some reasons for that. And I think that one reason would be that, again, the things that I talked about previously, that she is not, I guess, coordinating stories with the person who she's with. And the evidence is clear that the two of them were together outside of the police station when they're trying to make this report. So she is right there with her from jump. So I think that there are a number of reasons, I would suggest a number of reasons to find Helen more credible. Now, walking through incentives to lie, I think the most starking one is Carleona. What incentive does Carleona have to lie? And ladies and gentlemen, there is none. I would challenge Ms. Straub to get up here and explain why Carleona would come in here and lie. What does she have to do? She looked like she was having fun yesterday. You think she was enjoying that? What reason does she have to lie? We don't have a shred of evidence in this record of anything she has to gain from committing perjury, from cooking up this lie that day. An hour later, she is outside on this street trying to talk to the police, telling the dispatcher what happened. For what reason does she have? Because we heard their perspective, right? Their version of events is we showed up and we knocked, and then we argued for a second, and then we left. Okay, what would cause a switch to flip and say, you know what I'm going to do? I'm going to tell a lie about what happened. I am going to go and I'm going to make a false police report, which is a crime. I'm going to go commit crime one, make a false police report, and accuse my sister of beating me up. And then over a year later, I'm still motivated. We haven't talked since then, but I'm still motivated. I am going to come to court and I'm going to commit perjury, another crime, to get her in trouble. And while I'm not done. I'm going to drag my best friend into this. So I'm going to get her on board like, hey, Brie, I have an idea. What if we go and we commit perjury together to get my sister in trouble? How fun would that be? A nice friend activity. Let's go and perjure ourselves so that she's convicted of an assault she didn't do. High five, right? That's how teenagers spend their time now, right? They go and they make false police reports and commit perjury. No, that's ridiculous. Okay, that doesn't make any sense at all. Now let's seriously, is she getting money from this? Is she in some sort of lawsuit with her sister? It makes absolutely no sense. It makes absolutely no sense. Now let's take her lack of incentive to lie and let's contrast that with the motive that we have from the defendant. Okay, because Carleona made a pretty horrifying accusation against this person's husband. And we're not here to litigate that, to be clear. We're not here to litigate whether that actually happened, the details of that. What I am here to suggest to you is that Carleona, in the eyes of Rhonda Wade, just blew up Rhonda's life, and Rhonda's mad about that. The simplest explanation sometimes is the best. Okay, so let's put those two scenarios against each other. Scenario one, I'm mad at my sister because I lost my family because she made this accusation. I'm going to go let her have it. Option B, fun together activity with my best friend. Let's go commit perjury. Now, another thing that's clear about the latter two witnesses you heard from, Rhonda and Tella, is that the two of them sat down and got those stories straight. Their testimony was the same down to the letter. And it's clear what happened. They went in and talked to this investigator together, right? This mysterious defense attorney investigator we keep hearing about. They got together and they came up with their defense. They strategized to figure out how to get out of this. And they came in here and presented exactly the same story down to a T, even down to the word move. They both said Rhonda moved Carleona's hand out of the way. They both said, well, we were invited in. in that she opened the door, and there's this sort of open door policy. They both said we were going over there to talk to our mom, and we were invited in, and then she held up the hand in the face, and then hand is moved out of the way, and then we left. I mean, the extent to which they're telling the same story more than a year later, isn't that a little suspicious? We should be suspicious of that, because that is people, and they admitted on the stand, they've talked about this numerous times since, and they admitted on the stand that they sat down with an investigator. And I'm submitting to you right now that they are the ones who got their story straight to try and help her get away with crime. Now, let's talk a little bit about people's court, which I would suggest is an important piece of evidence. I'm going to sit down for this so that I'm not obstructing jury two's view again. Now, the thing that I'm going to emphasize here up to the cursor, we have the defendant here on the left, right? And let's just watch her go into the house. That is something I would just play this on loop all day. And now watch Tella's reaction to her going in. Watch Tella. Look at that. She's reacting to something that just happened. Okay, that is a person bursting into this room. I wish the video wasn't, freezing up frames the way it was. And I could just sit here and play this all day. She opens that door and she bolts in. And then you can see it. You can see it in Tella's face. See if I can pause it right on Tella's face. Look at that. All right, that is the chaotic scene that's already unfolding. You can see it right there in Tella's face. We saw Rhonda Wade burst through that door. Okay, and we see someone who is startled by what they see. Now, another thing that I think is worth noting is something that actually came out in response to a juror question. You guys had some very good questions. And it came out, someone asked, have you and Carleone talked since then? And at that point, it came out that Rhonda Wade's mother called her that day and said, don't come back to my house. Okay. Her mother said, don't come back to my house. And let's take a look at what Rhonda and Tella say happened. Rhonda and Tella say that they knocked on the door, and then Carleone came out and said, why the fuck are you pounding on my door like that? And then they argued, and she moved the hand, and then they left. And that's all that happened. That's all that happened. Why is her mother saying, don't come back to my house? Don't talk to Carleone anymore. You're not welcome. That doesn't make any sense. That doesn't make any sense. Let me tell you what does make sense. You saw her burst through that door. She burst through that door and she beat up her little sister. And then both their mothers said, don't. That right there doesn't make sense. And that's from the defendant's mouth right there. That is a critical concession. A critical concession. Now, what I just discussed with her mother begs the question, why didn't her mother come here and testify? Why didn't her father, who broke them up, come here and testify? And I am going to tell you now that the absence of witnesses does not cut in either direction. I'm not going to stand here now and say that, the case did a good job. We heard from Officer Fox, who I would suggest did the best that he could. Okay. At the end of the day, I'm not going to try and defend them, but I would suggest that he didn't even start work until 12 hours after this happened. Clearly, we have a crime victim who was let down. We came here wanting to get help from the police and sat out there for hours and is calling Central Dispatch and is saying, I want to make this police report, and they just never come out. She's sitting in that car and they never come out. And then she goes home And this is another corroborative thing, right? She said, oh, it was more than 12 hours later, and Officer Fox testified, oh, it was after midnight when I got there. So it's lining up. So this young lady tries to do what she's supposed to do, go to the police and get help. And I anticipate that the fact that the police did not meet her the way they should, the defense is going to say, that means you should reach a not guilty. And I would submit that that line of reasoning is fair. Okay, the lack of a police investigation and the lack, so obviously, the only people who were there when Officer Fox reported were Carliana and her mother. And then it doesn't seem as though he ever went and made contact with other witnesses. There's no indication that's record that any detectives made contact with any other witnesses, right? And that's not Carliana's fault. And I'm going to ask if you don't hold that against Carliana. And I'm going to ask if you focus on the evidence that is here, not speculate on what other people might have said. Okay, I don't want you to sit here and say, well, if this happened, then she would have testified to this, et cetera, et cetera. I want you to look at the evidence that you did get and focus on what it does tell you, and not take the lack of police work, the absence of witnesses to mean that, well, this must not have happened. Because both things can be true, right? The crime could have committed, and the police might have let the victim of the crime down. Now, I think that finally, where I want to end is I want to talk about what a reasonable doubt would mean in this case. Okay. Because one little exercise I like to do is where you ask yourself what else explains these facts. So what I want you to do is play out the defendant's scenario and then ask yourself, is this reasonable? So a not guilty verdict would mean you believe it's reasonably possible that Rhonda Wade and Pella Wells went over to this house to talk with their mother, that they knocked and then were invited in via opening door and stepping back. And then despite being invited in, Carliana then starts yelling and cussing at them and holding up her fist, that Rhonda then moves her fist out of the way and then they leave. And then after they leave, Carliana makes up this plan, this conspiracy to take down her sister. And they make a plan right then and there. And then they go to the police and spend hours trying to make a false police report. They're so motivated by this plan to frame her sister that they sit out there for hours. And then they go home and then police come after midnight and Carliana is still motivated to make this police report. And then a year later, they're still so motivated, they come here and they commit perjury. Okay, all of that, I want you to ask yourselves, is that reasonable? Is that possible? Sure. Okay, but is that reasonable? Is that a reasonable scenario? I want you to think about how people act, and let me posit a different scenario that I would submit is the only reasonable one. A different scenario is that Rhonda Wade is mad about her life getting blown up, and I'm not trying to pass judgment on her. I don't know what I would do in that situation. She responds to her anger by taking out her sister, and she, for some reason, decided this is your fault. I'm going to go and I'm going to take it out on you. And then her sister went to the police. And it took a while for the police to make time for her. And then she was telling the truth. Simple as that. And then the defendant doesn't want to get in trouble, and so she lied to you. And the defendant's sister also lied, he doesn't want to get in trouble. Which scenario there is realistic? I would submit to you that scenario one is so much more, that the scenario of guilt is so much more realistic, and the scenario of innocence is so absurd. So as a guilty verdict beyond a reasonable doubt is the only just outcome of this trial.
Sure.
Members of the jury, thank you for rejoining us today. At the beginning of this trial, I told you that this case is about an accusation between two sisters, and that accusations are not evidence. They still aren't. This case, as promised, will require you to look very carefully at the evidence. Let me address a few things that the people just said. You will indeed have to measure credibility. Okay? I won't tell you what you clearly saw in front of your own eyes and observed with your own faculties yesterday as these witnesses testified. I don't have to. You were here, you saw it, you listened. and paid attention, I saw it. I just ask that you use your common sense, okay, and evaluate what you saw based on your own faculties, based on your own experiences, based on the indications that they gave you. There is no issue with a person recalling an interaction that would later result in them being charged with a crime. Okay? As a defense attorney, okay, and God forbid any of you ever get charged unjustly with a crime, I would absolutely urge you to use all of your faculties to remember what happened, because you'll need them. Some day of trial, you'll need them. Criminal law requires the highest burden in all of the practice of law, okay? The beyond a reasonable doubt standard is the highest burden of proof across all practices of law. And that's appropriate, okay? Where people's liberty is at stake, the people should not be able to just simply arbitrarily lock people up or convict them of crimes. They should have to show beyond a reasonable doubt that a crime occurred. I won't deal too deeply in the motive. I think it's a distraction, okay? Your job is to evaluate whether or not a crime happened. You'll need evidence to do that. Look at the evidence. I just asked you to do that, evaluate the evidence. Assistant Prosecuting Attorney Marchmina is right. Both things can be true. The person, okay, the police could have failed to have investigated something, and a crime still could have occurred. That doesn't necessarily mean that that's what happened here, okay? The evidence has to show you that the crime occurred, okay? So even if, you know, that person is guilty, and even if the crime wasn't properly investigated, at trial, you have to see evidence beyond a reasonable doubt that that crime occurred. And if you don't see that, you cannot convict. The prosecution does not get a conviction because an allegation was made. It does not get a conviction because there was tension between two sisters. It does not get a conviction because someone later went to the police, okay? It must be proven, okay, that it was an intentional assault and battery, and it has to be shown beyond a reasonable doubt. I keep saying that, right? Because that's literally the crux of your job, is to use the standard to evaluate the evidence. As you evaluate whether the people met the burden, remember the facts, and let's look at those facts, okay? As you evaluate whether the people met the burden, remember the facts. Let's look at those facts, and let's look at the facts that amount to reasonable doubt. Number one, the report was made 15 hours after the incident is alleged to have happened. The prosecution case, their case, very much depends on Ms. Bauer's version of events. Unduly depends on her version of events and her statements. But her statement to police was not made immediately after this happened. Okay? It was made nearly a day later. That delay matters. And I won't attribute that to being her fault, okay? But we did ascertain statements to the effect that she did not want to press charges early in the day. Okay? Now, that gives time for reflection, for anger to grow, for details to shift, for an accusation to become something different from what actually happened. It also gives enough time to not do investigative work properly. Okay? Take photographs while those injuries, alleged injuries, are fresh. Okay? So that we know specifically that those came from this event and not from something else. We also know that police did not interview any of the witnesses other than Ms. Bowers. That includes Ms. Wade herself. Okay, she never was given an opportunity to explain to police what she saw that day, what she experienced. We did not, or excuse me, the investigator or the police, no one asked Ms. Wells what happened. Okay, we always knew from the very beginning when Officer Fox responded, he knew who was present. Names were given. He knew where they lived. He knew how to contact them, but no statements were gathered. They didn't, or he didn't, even check in with any of the neighbors, okay? Nor did an investigator follow up later, okay, to see if they maybe saw anything, received anything that happened that day. This fact is why the people are scrambling last minute to assert that Ms. Wells and Ms. Wade coordinated their stories, because they never gave statements to police. Those were never memorialized or taken down and documented. So he doesn't have anything to go off of. We heard from Officer Fox that it is not his job to investigate, but he did concede to the fact that it is somebody's job to investigate. And this process critically depends on that happening, because that's what you evaluate relative to evidence. It's what comes from this investigation. Ms. Wells denies any battery, any assault. She told us that Ms. Wade did not assault, did not batter Ms. Bowers, and she was there the entire time. She was close enough to witness all of this. She told us firsthand that what she saw was Ms. Bowers raise her hand and Ms. Wade moved her hand out the way. That at most can amount to self-defense. And we've not heard from the people relative to the testimony from those witnesses relative to self-defense. They have not met their burden. We don't know how Ms. Bowers sustained her injuries. She could not tell us that. Someone who was harmed could not tell us that. Her own words, an allegation she made. She can't tell us how she got her injuries. It's a question. It's reasonable doubt. Ms. Williams, we heard from the complaining witness's best friend, Ms. Bowers' best friend. And her story changed, okay? Right in front of your eyes. From direct examination to cross-examination, her version of events changed. What she alleged to have happened changed, metamorphosed right in front of you. The accounts don't match. That's probably one of the most notable things. We're supposed to look at those two witnesses, Ms. Bowers and Ms. Williams, and deem them to have had credibility. But their statements vary widely. It's not just a matter of memory having lapsed. It is literally a different attack was supposed to have happened. Ms. Bowers tells us that Ms. Wade pulled her hair, pushed her down, made her fall to the ground, was on top of her, okay? And then Ms. Williams tells us a very different story. She never saw hair being pulled. And Ms. Bowers is supposed to have fallen forward, not on her back. And apparently Ms. Wade is supposed to have also choked Ms. Bowers. And at some point, I guess during all of this, Ms. Bowers is supposed to have urinated, which she didn't say herself. Ms. Williams' statements don't appear at all to be consistent with what Ms. Bowers, the person who is supposed to have endured this experience, they don't match. Now, both of those witnesses are young. I do recognize that. But I think they're old enough to know the difference between telling the truth and fabricating. Now, all of this also is supposed to have happened within 1 minute and 47 seconds. Now, I'm a lawyer. Math is not always perfect, y'all, okay, but it's under 2 minutes. Okay, we'll go with under 2 minutes. And finally, we heard from Ms. Bowers herself that their father is supposed to have separated them. He is supposed to have seen them entangled, scuffling, and been the person to separate them. But for whatever reason, you didn't hear from him. Think about that. Ask yourself questions. Why would that be the case? Now, I have an empty card, okay? And this one I keep just for you, okay? I'm an imperfect human being. I can miss things. You may have picked up another reason or another fact that amounts to reasonable doubt that I didn't. This card is for you. If you agree with even one of these reasons, okay, in any of these examples that I have just listed out, then you have reasonable doubt. And if you have reasonable doubt, there's only one appropriate verdict, and that's not guilty. Remember what you promised me. Before all of this started during jury selection, that you'd be the type of juror you'd want judging you, that you'd be fair and impartial, and that you would decide this case based on the facts of this case. Not on distractions, not on unnecessary motives, but on the facts of this case. And if you do just that, there really is only one choice: to uphold the presumption of innocence, because the people simply have not met their burden of proof. I ask you today to find her not guilty.
Before I proceed, I just saw the defendant take the cards off and then throw them in half. And the defense put up a demonstrative and then I'm able to respond to it. I don't know what the, I guess if I mean, if you were to ask me to put the card back up, I think it's odd.
You can't use your demonstrative for her argument either. I don't know what you're asking for. It's not an exhibit.
Okay. My understanding
argument.
is like when they put up a demonstrative, I'm allowed to like engage with the demonstrative.
I'm not sure what happened. You said
Display the demonstrative.
you still have them.
I do.
I would like to have them or have cards if possible.
Could he point us to the court rule that expresses that, Your Honor? I am not aware of that court rule.
That's fine. We can move past that. I mean, I guess that's what you do when you don't have a winning argument, right? You take the argument from that kind of. So fully respond to it. So I suppose I will move forward without having the aid that they just put up and then put down and then torn it down. I want you to take note of that. All right. Which side is trying to be sneaky here? Okay. The side that has their witnesses getting together for meetings with investigators and then tearing apart note cards they put up so that I'm not able to fairly meet the argument that they make. Okay, when you engage in sneaky behavior like that, all right, that shows a guilty conscience right there. I mean, that's ridiculous. That's ridiculous. Don't reward that. Don't reward that nonsense. That sort of game. When you come in here and you're playing games in the court, trying to discreetly tear note cards in half and put them in a pocket so I can't respond to your argument. I mean, if I had a PowerPoint, they wanted to respond to slide in the PowerPoint, I'd put it back up. All right, that's called being fair, because both sides deserve a fair trial. Okay, when you're not interested in a fair trial, when you are destroying your demonstrative, the second you're done with it, that right there is when a guilty person does. That's ridiculous.
Counsel, can you approach?
Yes, Your Honor.
Chambers.
Okay, now the defense described motive as a distraction, and I would say the motive is not a distraction. That is evidence that is useful to you in guiding you towards making your decision. All right, the motive is not a distraction. It is important evidence. Now, the defense is correct that allegations are not proof. Allegations are not evidence. Okay, and you are instructed the fact that Ms. Wade is charged with a crime. That right there is not evidence of guilt. However, we have beyond allegations. We have sworn testimony from witnesses who were placed under oath. That right there is not just an allegation. That is evidence. Now, there is a lot of emphasis on the fact that the police did not take the report until much later. And there is a line in the police report saying that the police responded earlier and the witnesses did not want to give a statement. And the defense so desperately wants that line in the police report to be true. Okay, and they're trying to find a way to make that true. But the evidence on this record that we have suggests that it's not true. Okay, we have testimony from Mark Fox saying that he was writing down what was in dispatch notes. And we have testimony from two witnesses who said that the police did not come at the time that happened. Okay, so that is something that is not true, that is being pointed to. Now, in general, there's a lot of attack on the police investigative force. And that is something that is done when the facts are not on your side, right? The facts that we have are not on the defense's side. There was conversation of the police did not interview the witnesses at that time. Well, to that, I would say, yeah, I wish that they had. I wish that we had interviews from Teller, for example, at the time this happened, but there were 4 people who were involved in this, and you heard from all 4. So you don't have to wonder what might have you gotten, because you heard from all 4. So there's no mystery. The one person who was at least partially involved in this was Carlene's dad, who it sounds like in the testimony he came in and he broke it up. So the defense is asserting there's this self-defense claim as well, and he wouldn't be able to speak to how it starts. The 4 people who can tell you what happened, you heard from all 4. Now, finally, there was one card that said 1 minute and 45 seconds. The implication being all of this couldn't happen in 1 minute and 45 seconds. Let's see, right, or 47 seconds. Let's see how long 1 minute and 47 seconds is, and you can tell me if that's long enough for what we described as that. Now ask yourselves, is that enough time for Rhonda Wade to burst in through the door, grab her sister's hair, tap her onto the ground, punch her a few times, pin her down, and scream at her? Yes, yes, that was enough time. Clearly that could have happened in 1 minute and 47 seconds. Bust in the door, hit someone a few times, pin them down, dad breaks them up. That's plenty of time. Now, finally, the thing I want to leave you on that I think is so important. This is a conspiracy defense. That is what it is. The defense being put forth is that these two young girls conspired to convict this person for crime she didn't commit. Okay, and I put forth a challenge to Ms. Robb, and she has no obligation to meet my challenges or respond my arguments, to be clear. She had no obligation to do that, but I said, I challenge Ms. Robb to present you with a reason why Carliana would do this. With something that Carliana has to gain from committing multiple crimes in order to get her sister in trouble. And of those note cards that were on the board, none of them included a reason. None of them included something that Carliana has to do. And for all of these reasons, I'm asking you once again to find the defendant.
One of these jurors is alternate, so you do not have to go to the deliberate. Number one. Juror number one, you're free to go. You can leave that there in case they're not able to deliberate and someone doesn't make it through, we'll call you back. Remaining jurors, you again have to pick a four-person. You will get a full copy of the instructions. If you have any questions or you want to review any of the exhibits, have your four-person write that down on a note, tap on the door. Someone will be outside the door monitoring. You slide it to them. No direct communication should be made of you with anyone outside, and also don't let anyone know how your voting stands. And if you have any other questions or concerns, you will do the same thing by tapping on the door and writing down the concern or the question. So you are going to be released now for deliberation. Is someone else going to come in here? Maybe Star. Thank you. Do you solemnly swear that you will, to the utmost of your ability, keep persons sworn as jurors on this trial from separated from each other, and that you will not suffer any communication to be made them or of them orally or otherwise until the time that a verdict is rendered? Thank you. You may be excused for deliberation. Stay close because I'm sure there will be maybe a question or a request to see the exhibit soon. We have Mr. Markarian in the building. How are you? I'm doing well. Are you like just stopping to visit us? Are you like doing some landlord tenant action?
No landlord tenant.
Oh, that's too bad.
Sorry to disappoint. Just stopping to say hi.
Oh, it's good to see you.
I've got a form I need you to sign. If you don't mind as well.
You can approach.
Where?
We have paperwork. You ready on the wire?
I am.
Oh, you have it. Do you have the paperwork?
I do.
Okay, very good. Kind of dark, but that was- Here. Carolina Flats versus Antoine McGuire, 26-4118. Council have your appearance.
Good morning, Your Honor. Attorney Hamza Sold on behalf of the plaintiff.
Okay, you're Antoine McGuire?
Yes.
Okay, Mr. McGuire, you were scheduled for hearing today. This is for non-payment of rent, is that correct?
Yes.
Okay, there's a landlord-tenant consent judgment that you've signed, is that correct? That's your signature?
Yes.
You want judgment to enter against you for the past due of rent, $1,498.71. Court costs $180.29 for a total due $1,679. Is that correct?
Yes. Ma'am.
And that you'll pay that amount, or you'll have the property vacant by the 24th of this month? Anyone threatening you to get you to enter this agreement? You understand that you have the right to have an attorney represent you?
Yes. Ma'am.
You wish to waive that?
Yes. Ma'am.
You also have the right to proceed to a trial. You could have demanded a trial. Do you understand that?
Demanding a trial.
You could have demanded a trial.
I mean, I really don't need a trial. I mean, I'm in jail right now, so it's basically like, it was like, I don't know, like, I have it paid by then, but I mean,
Yeah.
I want to demand a trial. And
Still your right. So I'm just making sure you understood that that was your right. Okay. Did you want to waive your right to have a trial on this?
Yes.
Okay, no one's forcing you to do that either, correct?
No.
Just gonna change their rate there to the 24th, to the 21st. You have 3 business days to return to the court. If once you leave here, you can give them a copy, please. You realize you misunderstood your right. You can return to the court and request to have this set aside, okay? Any additional matters for the record?
Nothing further to complain about. Thank you.
You have perjurious wait.
Oh,
Mr. Markarian? Thank you.
Thank you.
have to look at this.
Thank you. Hopefully I'll see you again soon.
Please, don't be a stranger.
I've been talking with Mr. King.
Oh, boy.
Nice to be there.
Got it. That's good. Good to know.
He does.
See ya. Okay, this is Arbor of Georgetown versus Jasmine Patterson, 26-04139 LT. Appear to the record.
Good morning, Your Honor. Lawrence Craftsman, standing in for David R. Pantera on behalf of the plaintiff.
Okay, you're Jasmine Patterson, correct? And thank you, counsel, for returning. I think she came just right after you walked out. It says here that there's a consent order for conditional dismissal. The matter will be dismissed upon the condition that you pay the past due amount, $2,768.29. That's for rent due through a period of August 31st, 2026, correct? Okay, it says you're gonna pay $500 by the 14th of this month, $500 every 2 weeks on Friday. All payments will apply first to your current rent and utilities, and then any extra will go up, be applied to the arrears. Is that correct? And that's your signature. You understand that you have the right to have an attorney represent you in this case. You want to waive that? You also have the right to proceed to a trial or a hearing. You could have made a demand for jury trial. Do you understand that? Okay, do you want to waive that right as well? Okay, partial performance will not satisfy this, so that means you got to pay according to what you say you were going to do here. If you don't, they can have judgment enter against you. You will not get a new court date. You understand that? You have any questions? You have 3 business days to return to the court and request to have that set aside. If you later realize you misunderstood any of your rights, okay? We'll get you just a copy in just a moment, and then you're all set. Thank you. Mark, let's see. Oh, yeah.
You presented that, she signed it and you raised it.
Okay, she does. Okay, Ling Brewer versus Tracy Metcalf, 26-04043. Okay, your appearance again, counsel.
Yes, Attorney Marcus Valdori on behalf of Brewer.
Okay, so my understanding is that you do now want to waive your right to have an attorney, correct? No one's forcing you to waive that right.
No.
You also want to waive your right to trial? Okay, judgment for possession and money judgment will enter in the amount of $3,450 with judgment agreement for you to vacate the property by the 10th of September. You have 3 business days to return to the court and have this set aside if you later realize you misunderstood any of your rights, okay? No problem, we'll get you a copy in just a moment, okay?
Thank you so much, Judge.
No problem. Sorry, you can get copies for that one, thank you. Okay, and then we have 900 Long Tech versus Tracy Perkins and all other occupants, 260390.
Good morning, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
Your name?
Jay Lazar on behalf.
Oh, you don't have Tracy Perkins here, correct?
Oh, no, he's not here, Your Honor.
Okay, so there's a default to enter in the amount of $3,273, is that correct?
Yes, it's possession only.
Okay, that will enter, get your copy in just a moment.
Thank you.
No problem. Let's see. This is Todd Doward and Whitney. I know Whitney. No, I see Jasmine. It's
maybe that's what it
Patterson.
was.
Yeah, what happened to Todd Doward? Is Whitney Patterson here? No. Okay, let's see. Who's here for Cox?
I am, Your Honor.
Okay, Mallory Porterfield sent an email, she's not coming. Do you have a default?
I do have a default.
Do you have any other matters ready to go?
Yeah.
You give me both defaults. All right, she sent an email, so she's not coming, and a bunch of attachments about court dates that have, medical appointments that have nothing to do with today. Okay, default as to NEMSEC. And default as to Porterfield. And then you say you have who ready to go?
Here, there's 3 consents.
Okay, thank you. Let's see, Baltic Flats versus Daniqua Ball, Justin Bullock, and all other occupants, 260415.
Good morning, Your Honor. Attorney Hamza Silva on behalf of the plaintiff.
State your name, please. Your name, please. Okay, today was the date scheduled for hearing for non-payment of rent. You have a consent judgment. It says that you all are both agreeing to judgment entering an amount of $2,415 plus cost $221.88 for a total due of $2,636.88. Is that correct?
Yeah.
And that you'll pay that or vacate by the 31st of August. Is that accurate?
Right.
Okay, did you both sign this?
Yeah.
You both understood your right to have an attorney represent you today, correct?
Yep.
You want to waive that right?
Yeah.
You both have the right to proceed to trial. You could have made demand for jury trial. You understand that?
Correct.
Yes. You both want to waive that?
Yeah.
No one's forcing you to waive these rights, correct?
No.
You have 3 business days to return to the court and request to have that set aside if you later realize you misunderstood your rights, okay? We'll get you a copy in just a moment. Any questions? Anything else on that record?
Nothing further. Thank you.
Thank you. You're all set. Thank you for your patience as well. Let's see, Briar Cliff Apartments versus Taylor Cement and all other occupants, 260415. Appearance, please.
Good morning, again, Your Honor. Attorney Hamza Silva on behalf of the plaintiff.
Your name, please.
Taylor Simmons.
Okay, Ms. Smith, thank you for your patience as well. This is a consent judgment today. It says that you were consenting to judgment in the amount of $4,740 for past due rent plus cost $183.55. Total due $4,923.55. And you'll pay that or you'll vacate the premise by the 31st of August. Is that correct? Okay.
Put 1,000 on it yesterday too.
You said you put 1,000 on it yesterday? Okay, so, but that hasn't cleared yet.
And it takes, they said it takes 24 hours.
Okay, so then it will bring that balance down. Okay. Okay, and so you also understand that you have the right to have an attorney represent you today. You want to waive that right? You don't know if you want to waive the right? You want to hire an attorney to represent you?
I don't know. So no.
Okay, so you want to waive the right to an attorney and represent yourself? You also have the right to proceed to trial. You could have made a demand to for a jury trial. You understand that? Do you want to have a trial? You need to use words.
No.
Okay, no one's forcing or threatening you to waive these rights, correct? Who's forcing?
Oh, no.
Oh,
I thought you were saying like correct, no.
oh, okay,
No.
that's valid, okay. Okay, you have 3 business days to return to the court and request to have this set aside. If you later realize you misunderstood your rights that you waived, you can file a motion to set that aside and explain how you misunderstood your rights. We'll get you a copy in just a moment. Any additional matters for the record?
Nothing further. Thank you.
Thank you. You're all set.
Thank you.
I'm assuming you're Adrian Kidder. Okay, this is Byron Cliff Apartments versus Adrian Kidder and all other occupants 2604162. Appearance, please.
Attorney Hamza Silva on behalf of the plaintiff.
Okay, Mr. Kidder, thank you as well for your patience. This matter is set for hearing. This is for non-payment of rent. It says possession judgment will enter past due amount of $2,224.31, correct?
Yep.
Plus court cost $183.55 for a total past due $2,407.86, and that you'll pay that or vacate by the 31st of this month. Is that correct? You have the right to have an attorney represent you today. You understood that right, correct? Are you waiving that right? You also have the right to proceed to trial. You could have made a demand for jury trial. You're waiving that right as well? Okay, no one's forcing or threatening you to waive these rights, correct?
No.
You have 3 business days to request to have that judgment set aside if you later realize you misunderstood any of your rights, okay? We'll get your copy in just a moment. Any additional matters for the record?
Nothing further. Thank you.
Thank you. You're all set. You can be seated.
Is that close enough for you guys? I think they wanted to see it closer.
Okay.
I don't know if they can.
I think there's one.
But depending on, a screen, we can get this. Either you stand over there.
Well, I think that I would help by like zooming in on that screen. I think I can get it zoomed in. Zoom to- Almost there.
Is you satisfied with that?
You want me to bring the computer up to you?
That would be.
Also slow it down. Can you see the other one or just that one?
No.
How's that?
Yep.
Okay. Good afternoon. What's your name on the iPhone? Ma'am, what's your name?
Amber Shank.
Okay, thank you. What's your name that's identified as Zoom user?
Yes, my name is Sultan Zubair.
Okay, thank you.
You're welcome.
What's your name that just logged on with the iPhone?
Tamara Parkey.
Okay, thank you, Ms. Parkey. What's your name, ma'am? Can you speak a little louder for me? Okay. Is that all we have? Which matter are you here for?
I'm with Lansing 74.
Are you an attorney or a property manager? Okay, so I see Lakeisha. Is it Dickerson, ma'am?
Yes.
Okay, I see Amber Shank, Tamara Parkey. I do not see Johnny Campbell. Who is Johnny Campbell? Ms. Shank, can you unmute, please?
Yes,
You know who Johnny Campbell is?
I do. He's currently asleep, I would assume.
He's in the home with you?
No, not with me.
Oh, okay. Do you live in the property?
I am living in the property.
Okay. Let's see. Tamara Parkey? Do you know who Johnny Campbell is? Unmute, please.
He's a roommate.
He's what?
He's a roommate. I know he works nights. I'm not sure if he's here or not.
Oh, okay.
I stay
So
downstairs.
is it one house and you all have separate rooms? Is that what's happening here?
Yeah.
Okay.
I stay in the basement.
Got it. Okay. Thank you. Is Antoine Benson here? No. Nobody's in the hallway, I presume. Destiny Williams, no. How was service?
They have second personal and other stuff.
Let's see, Mr. Ingram, you can submit default on that matter.
Understood. Thank you, Judge. Appreciate it. You have a good afternoon.
Same to you. Okay, I'm gonna play a video for the rest of you all. The video will go over your rights. The video will also advise you of resources that you may be eligible for during this eviction process and then possible ways to resolve this matter. At the conclusion of the video, there are representatives here from legal services. You are free to meet with them after the video today so that they can do an intake to see if you're eligible to be represented by their office. I'll also get you your next court date. You must appear in person for that next date. That date is the date scheduled for a hearing. Let's play the video first.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver.
Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Advent House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge. Okay, this is Swasan Zubair versus Lakeisha Dickerson. This is 266-04204. Council appearance, please. Or appearance name for the record.
Hello,
State your name for the record, please.
my name is Sousan Zubair.
Okay, and then I do see Lakeisha Dickerson here. Zubair, are you representing yourself? That's correct?
Yes.
Okay, and then Ms. Dickerson is here. Ms. Dickerson, did you hear your advice of rights?
Yes.
Do you have any questions about those rights?
No.
Okay. Your matter is scheduled for hearing. You must appear in person at the court on August 26th at 8:30, okay?
Okay.
Did you want to meet with legal services today?
Yes.
Okay, I'm gonna put you in a private meeting room. Let's. Ms. Grossman, are you available?
Yes, I am, Your Honor.
I'll add them to your room. Let's see. One. And Ms. Zubair, you're free to go for today. We'll see you on the 26th.
26 at 8:30.
Yes, that's correct.
Thank you.
Thank you.
Bye-bye.
Now, this is GL Home LLC versus Amber Shank, Tamara Parkey, and John Campbell, 26-04209. Council appearance.
Good afternoon, Your Honor. Roger Smith appearing on behalf of GL Home LLC.
Okay, and I see Amber Shank is present as well as Tamara Parkey. Ms. Shank, did you hear your advice of rights?
Yes, ma'am.
Do you have any questions about those rights?
No, ma'am.
Okay, what about you, Ms. Parkey? Did you hear your advice of rights?
Yes, ma'am.
Do you have any questions about those rights?
No, ma'am.
Your hearing is scheduled for August 26th at 8:30 in person at the court, okay?
Yes, ma'am.
Full service for Campbell. Ms. Shank, did you want to meet with legal services today?
Yes, ma'am.
Substitute, but they have set the meeting.
Okay, and then counsel, you can default Johnny Campbell for failure to appear.
Thank you, Your Honor.
Problem. And then Ms. Karki, did you want to meet with legal services?
Yes, ma'am.
Okay, Trey Taggart, are you available?
Yes, Your Honor.
I'm gonna put Ms. Shank in the room with you. Okay, and then I believe Deshawn, can I put Tamara Parkey in the room with you?
Yes, Your Honor. Thank you.
Hello.
Thank you. 1 second, please.
Good. How are you?
1 second. Okay, this is Gary Calkins versus Rashonda Lilly in file number 26-04378.
We're with you, Carrie, on behalf of plaintiff.
And state your name for the record, ma'am.
Rashonda Lilly.
Okay, Rashonda Lilly is present in person at the court. Did you hear your advice of rights? Do you have any questions about those rights?
No.
Okay, your matter is scheduled for hearing in person at the court on August 26th at 8:30, okay? We'll get your notice to appear. Did you want to meet with legal services today? Okay, then you're free to go once you get your notice. Thank you. Okay, Taylor James, please start your video. Someone named Makia, please start your video. Can you give me your last name, please?
Thomas.
Makia, is it Makia or Makaya?
It's Micaiah.
Makaya, thank you. Okay, I see Makaya Thomas. I see Ms. James, can you adjust your video so I can see your face?
Hold it like this.
Taylor James?
Yes.
Okay, very good. Okay, someone just joined from iPhone. What's your name, ma'am?
Shantae Guy.
Shantae Guy. Okay, very good. And then there's someone else. Let's see. Do we know who this person's sitting here is?
She is a plaintiff. Ms. Who?
Ms. Who?
H.U.
Okay. Okay, can you unmute, please, sir? Are you driving? Sounds crazy. Move. Okay. You can appear in person when you figures out you don't drive for it. Okay, I see Ms. Guy again, Ms. James and Ms. Thomas. Today's the date scheduled for a pre-trial. This is an eviction proceeding. I'm going to play a video that will go over your rights. The video will also advise you of resources that you may be eligible for, and then possible ways to resolve this eviction. At the conclusion of the video, I'll get you your next court date. You must appear in person for that date. That date is scheduled for your hearing. And then we have representatives here today from legal services. Their purpose here today is to do intakes with you if you'd like. They can see if you're eligible to be represented by them for free, okay?
Okay.
Let me play the video for you now.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
Lansing Green Properties versus Ashante Guy, 26-04377. Council appearance, please.
Joy Woody appearing on behalf of plaintiff Lansing Green Properties.
Okay, Ms. Guy is present via Zoom. Ms. Guy, did you hear your advice and rights?
Yes, ma'am.
Do you have any questions about those rights?
No, ma'am.
Okay, your matter is scheduled for a hearing in person at the court August 26th at 9 a.m., okay?
August 26th.
That's correct.
Okay, I just didn't know it was 5 or 6. Okay, I got you.
2-6, yep. Do you want to meet with legal services today?
I do.
Okay, hang tight. Let's see. I believe it's shown. Can I put her in your room?
Yes, Your Honor.
Okay, I'll put you in room 3.
Thank you.
Let's see. Thank you. You're already in room 3, Mr. Sean. Okay, let's see. This is Lansing 74 versus Taylor James 26-04381. Parents, please.
Good afternoon, Your Honor. Attorney Samantha Smith, on behalf of plaintiff.
Okay, and is it Taylor or
It's Talia.
Talia? Talia,
Talia.
okay, great. Talia. Talia, did you hear your advice of rights, ma'am?
Yes.
Okay, do you have any questions about those rights?
No.
Your matter is going to be set for hearing and it's in person at the court August 26th at 9 a.m., okay?
Okay.
Okay, did you
Let me
want to
write
use
that
legal
down.
services? No problem.
At 9, August 26th?
August 26th, 9 a.m., yes.
Okay. Okay.
Did you speak with legal services?
No, it's okay.
Okay,
Well, I
we'll
have a
wait.
question.
Yes.
Is that something that I should do? I know that we had came up with like a payment plan that works for me. So is that something that I should still do or?
You would want to meet with legal services if you believe there's a lawful reason maybe that you're withholding your rent, or if you think that there's something that you need to litigate and hold a hearing or trial on. But if you're just a past due rent that you want to make a payment plan, you and the attorney can execute that in a private meeting room. If you already have a payment plan, I don't know why that wouldn't have been turned over to the attorney already, but the attorney can get that information if they're able to today. Is that the property you're here for?
Yeah,
Okay, is there a payment plan?
it wasn't signed, so it's not.
No, I know, I get that, but even if it was, it's still gotta go on the record. So, is she able to do a payment plan today?
Yeah.
Okay, so counsel, your client is here. I can put you all in a private meeting room.
That would be wonderful.
Okay. And then if you resolve it today, you don't have to come back on the 26th.
Okay.
Let's see. That's right.
And if my client could step outside, I'll call her on my phone.
Sounds good. Just want you to step out. So we get James and.
And I do have Micaiah Thomas next. Do you want to call that case before I go to the break?
Right now, yep, very good. Okay, this is Lansing 74 Limited versus Micaiah Thomas 26-04382. Can I have your appearance on that one, counsel?
Attorney Samantha Smith, 819 appearing on behalf of plaintiff.
Okay, Ms. Micaiah Thomas is present via Zoom. Ms. Thomas, did you hear your advice of rights?
Yes, ma'am.
Do you have any questions about these rights?
No questions, but I did receive an offer to make a payment plan. I just didn't go all the way through it until I wanted to come to court first before I made the payment plan because I hadn't, when she offered me to do the payment plan, I didn't have orientation yet. I was still getting my TB test done, and I was still going through the hiring process. But she did offer me a payment plan that works for me, and I'm already signed up through DHS. DHS said they were going to help me, but I just didn't have a summons yet. So I did upload my summons and my documents to DHS to try to get some help.
Okay, so you think that you could probably resolve it today if you meet with the plaintiff and their attorney?
Yes.
Okay, so we'll put you in a separate meeting room, and then when the attorney is ready, they'll handle yours. I'm gonna have her meet with the other person, Ms. James first, and then with you, okay?
Okay.
Okay, thank you. Let me put you in room 5. Thank you.
Thank you, Your Honor.
You're welcome.
Your Honor, I do have a plot coming up at 12 on behalf of 774. I'll be back as shortly as quickly as I can.
I'm sorry?
I have a third hearing for Christopher Williams. I don't see him in the courtroom now. I wanted to advise you that.
Oh, okay. Yeah, that's about 30 minutes out, so you're fine. Thank you. Ms. James, can you return to the breakout room? The attorney's gonna go in there now.
Okay, thank you.
No problem. Sir, what's your name?
Yes. Chris Williams.
Are you the person who was driving in my courtroom?
Yes, unfortunately, I was literally just parking in the driveway and I just got out the car as soon as I got kicked out the room. But I'm out the car now.
I saw more than a driveway, that's for sure. What's your last name?
Williams.
You need to get stationary. I see Michael Hall.
Yep.
What exactly is happening? Mr. Williams, are you ready for court or are you on a walk?
No, I'm ready. I'm sorry.
Yeah, you have to be stationary. Really, when you drive in court, we make you appear in person because you know you're not supposed to be distracted driving anyways. And operating a device, logging into Zoom while you're operating a motor vehicle is against the law.
Okay, I'm sorry. I apologize. I won't do it again. But I'm stationary now. I'm inside, so I'm listening.
Yeah, just let me know when you're ready.
I'm ready right now. Hi, awesome.
And a gentle reminder not to tell you where the voting is.
That's the whole. You can have a seat.
It's very fair.
Well, to their credit, they didn't tell me which side they were leaning.
That's true.
It's just, you know. Okay, you can have a seat. Mr. Williams, and then Mr. Hall, today's scheduled for a pretrial. This is an eviction proceeding. I'm gonna play a video that will go over your rights. It will also advise you of ways that you could possibly resolve this. And then potential resources that you may be eligible for. At the conclusion of the video, you can meet with legal services. They are here today to do intakes to see if they can represent you for free. And then also, I'll get you your next court date. You must appear in person for the next court date. Let me play the video first. Oh, wow.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Advent House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
I don't think the attorney for Hall is here yet. Tua? Okay. Okay, let's see. Lansing 74 versus Christopher Williams as 26-04393. I believe, sir, the attorney for your matter is Mr. Williams. Can you hear me? See, Mr. O'Reilly. What's happening? I don't know about the experience.
Can you hear me?
I can hear you. Okay.
Okay.
Did you hear your advice of rights?
Yes.
Are you engaged in something right now that's distracting you?
No, I'm listening.
Do you have any questions about your rights?
No.
Okay, your matter is scheduled for hearing in person at the court August 26th at 9:30, okay?
August 26th, 9:30.
Did you want to meet with
Okay.
legal services today?
No.
Okay. The attorney, I believe, for your matter is meeting with other parties to see if she can resolve the matters today. You can hang on if you'd like to do that today as well. Otherwise, you're free to go and we'll see you in person for your hearing.
Okay. And one more time, you said August 26th, 9:30?
That is correct.
Okay. Thank you so much.
No problem. How was
Bye.
the service on Henry Snyder? Person. This is Shijing Hu versus Henry Snyder, 26-04416. Let's for termination of tenancy. It was scheduled for today at 2 o'clock. It's 2:13. Henry Snyder has failed to appear. Default can enter. Ms. Hu, did you know how to complete default paperwork?
I have all the people.
You have a default judgment? Okay. Do you know how to do a default judgment, Mr. Metz?
Negative.
Can you see if, oh. Well, we gotta bring the jury up. We need somebody, you're Stephanie. Or somebody. And there's Senator Silver. It could be, who else is down there? Great. They got days. Brittany, she might be.
What was it?
Just the fact that.
You can be seated. Okay. I did receive some questions that required me to bring you in here to address another jury instruction. It's the first question that you all submitted was what happens if some of us agree on guilty of assault but not battery? Other question, which essentially, ironically, they have the same answer. What happens if only one person disagrees with the rest of us? There was a jury instruction that did advise you that all verdicts must be unanimous. So unless everyone individually agrees, then it's not a unanimous verdict. And since you all indicated that you all are at that point, I'm going to move forward with another jury instruction, which we would normally give you only after you've indicated that you're deadlocked or you can't come to a unanimous decision. You have returned from deliberations indicating that you believe you cannot reach a verdict. I am going to ask you to please return to the jury room and resume your deliberations in the hope that after further discussion, you will be able to reach a verdict. As you deliberate, please keep in mind the guidelines I have given you earlier. Remember, it is your duty to consult with your fellow jurors and try to reach an agreement if you can do so without violating your own judgment. To return a verdict, you must all agree, and the verdict must represent the judgment of each of you. As you deliberate, you should carefully and seriously consider the views of your fellow jurors, talk things over in the spirit of fairness and frankness. Naturally, there will be differences of opinion. You should each not only express your opinion, but also give the facts and the reasons on which you base it. By reasoning the matter out, jurors can often reach an agreement. If you think it would be helpful, you can submit to my court officer a written list of issues that are dividing or confusing you. Then it will then be submitted to me. I will attempt to clarify or amplify the instructions in order to assist you in your further deliberations. When you continue your deliberations, do not hesitate to rethink your own views and change your mind if you decide it was wrong. However, none of you should give up your honest beliefs about the weight or effect of the evidence only because of what your fellow jurors think or only for the sake of reaching an agreement. So I am going to send you back to further deliberations. We did receive your lunch orders and I believe those are en route. And then if you want to compile a list of some issues that you think might be causing confusion, then you can submit that list and we'll see if we can address them for you the best we can. Let's see, and you guys submitted some really great questions. Some of them we couldn't answer because they were questions that you had to ask the person who was sitting there. So we're not able to answer it for you. Other than that, you're doing a great job. So you're free to go deliberate. Ma'am, can you unmute your device, please? What's your name?
Piggies.
Oh, thank you. Okay, I believe. I'm sure I'll look up this here. Drew was not here for this matter. Matter wasn't dismissed, right? Michael Hall. Oh, here goes Bach. He's probably here on that. I don't know. He might be here for Brown. That's not dismissed though. Mr. Bach.
Good afternoon, Your Honor.
Good afternoon. Which matters are you here for? Are they the 230 matters?
I'm here for the Sam Dua, 1418 Vine Street, Michael Hall.
Right. Yeah, he is here. I'll call that case now. 1418 Vine Street LLC versus Michael Hall, 26-04437. I can have your appearance for the record, counsel.
Yes, good afternoon, Your Honor. Ronald Bach here for the plaintiff.
Okay, Mr. Hall is present via Zoom. Mr. Hall, did you hear your advice of rights?
I did.
Do you have any questions about those rights?
I do not.
Okay, your matter is scheduled for hearing in person at the court August 26th at 9:30, okay?
August 26th at 9:30. I got him.
Do you want to meet with legal services today?
I do not.
Okay, you're free to go. Thank you.
Appreciate it.
No problem. And then Ms. Pegas, I'm going to play a video that will go over your rights. It will advise you of ways that you could resolve this matter and then potential resources that you may be eligible for, okay? Let's see.
Sounds good.
Welcome to the 54A District Court.
Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Advent House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838. Option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
City View Apartments, 503 South Capitol versus Kiara Pegas, 26-04442, appears to be.
Good afternoon, Your Honor. Cheryl Welkoff on behalf of the plaintiff.
Okay, and Ms. Pegas is here. Did you hear your rights and rights, ma'am?
Correct.
Do you have any questions about those rights?
No.
Okay, your matter is scheduled for hearing in person at the court the 26th of August at 9:30, okay?
Okay.
Did you want to meet with legal services today?
No, thank you.
Okay, well, you're free to go, ma'am.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you. Okay, let's see. Let's see the attorney for James, but I guess she's meeting with that person. Is that what's going on? Yeah.
Absolutely.
Okay, this was a non-payment of rent or termination of tenancy. This was termination of tenancy. Right,
Hugh
Snyder.
termination.
Yeah. Give her a copy.